a local chief executive or a mayor because of corrupt practices. So hindi po tayo titigil dyan. And this is really the reason why we are conducting this webinar, for you to be refreshed of your responsibilities and the laws to prevent corrupt activities amongst local officials. And more importantly, the need of the public or the general public through civil society organizations to be part in the whole process of bringing down corruption, at least in the local government units, as part of the DILG. In other words, we call on integrity and accountability in government service to be able to strengthen the trust of the public. And again, as to repeat, this webinar is to re-echo the responsibilities of local officials and employees to protect the integrity of government and be reminded of their sworn duties as public officials. This will also tell our civil society organizations and give them knowledge as regards what are the existing laws and statutes which they can anchor for purposes of corruption complaints. Let us remind each other that for us to have the change that we want, citizen participation is critical. No country in this world developed or progressed without the participation of the ordinary citizen in the fight against corruption and in the development of any economy. In other words, participatory governance is good governance. And to be able to do this, we have to change the culture of the ordinary Filipino, their behavior towards government, to be part of the whole process and governance, and to say that to be able to have change or experience change, we have to be that change itself. Na tayo po ang pagbabagong hinihingi ng ating bayan. Ang aktibong koordinasyon ng tao at ng pamahalaan ay esensyal para mapanagot natin ang mga korap na opisyales na nag-aharian ng mga nakaraang administrasyon na sa aming pananaw ay dahan-dahan na pong nawawala. Hindi po ito mawawala ngayon, bukas, sa isang linggo, sa isang taon. Pero sa katagalan po, kung patuloy nating lalabanan itong korupsyon sa mga lokal na gobyerno, mapapababa po natin ang korupsyon at marami sa pera na dapat nananakaw ay magagamit na para sa benepisyo ng ating kababayan Pilipino. This collective action is very important if we really want to change the system for purposes of good governance. So with this, again, I thank everyone who are present today. I see that we have a lot of people who are present today in this webinar, and I do hope that we will be refreshed of these laws against corruption, and more importantly, use this as a tool to be able to fight corruption in the locality. More importantly, with our civil society organizations being part of the whole process of fighting corruption. Magkakasama po tayo at gagawin po natin ito dahil ginagawa po natin dahil mahal natin ang ating bansa at dahil ginagawa natin ito para sa bayan at para sa tunay na pagbabago. Magandang umaga po sa ating lahat.
Thank you very much, Undersecretary Densing. And thank you for reminding us that citizens' participation is good governance and that tayong mga ordinaryong Pilipino ang pagbabago. Thank you very much again for your time, sir. Bye po.
Salamat.
Thank you po. Now, moving forward, kindly check the chat box later. Magkakaroon po tayo ng pre-assessment. So we will be sending the link dito sa ating chat box para makita po natin ang ating kaalaman regarding sa mga matututunan natin kung anong level na po. And after that, meron tayong post-assessment. And also the attendance link will be sent later pagkatapos po ng lahat ng ating mga discussions for this morning. Ayan po. So again, magandang umaga po, especially din po sa ating mga local chief executives na kasama natin ngayon. Okay, so let's move para po makarami tayo. Let's move to our first session, which is the Bantay Korapsyon program. So with this session, we will be discussing what is Bantay Korapsyon, citizen participation in anti-corruption. So let me introduce to you our first lecturer or speaker for today. Yan. He has more than 28 years of political experience in directing and managing several multi-sectoral community, organizing youth and students, urban poor and fisherfolk, including community-based development programs and projects. He is also a campaign administrator. He has conceptualized and initialized the nationwide implementation plan on federalism, dubbed as Kamtin ang Pagbabago Tungo sa Federalismo, from November 2016 to December 2018. He has also deep stock knowledge and skills in conducting political research work, strategic planning, assessment summing up, comprehensive organization development, and political education work. He's also an expert in applied sociology, social movements and organizations, expert in facilitating trainings and seminars, in political campaign management and administration, and in public speaking and manifesto writing skills. He's also graphic arts and website designer. Wow. He is, of course, with the DILG since July 2018 to present, and he is our Program Development Officer 3 for Bantay Korapsyon program. Also, kasama po ng kanyang work sa DILG, meron din po siyang mga affiliations sa mga iba't ibang organizations. Like, he is a board secretary for Advocacy Center for Community Enterprise and Social Services. He is the founding president of the People's Council for Change, or PCC. He is the National Secretary General for Mula sa Masa Duterte Movement, MMDM Incorporated, and the Vice President of Alyansa para sa Bagong Pilipinas Incorporated, or ABP. Also, he is the Program Consultant and Sustainable Farming Trainer sa Pure Organic Feed the Soil, Not the Plants. Wow, Executive Director din po siya dati ng Greeneration Philippines Incorporated, and former Executive Director pala siya doon. And he graduated at Arellano University in Manila in college, and in high school from Arellano University as well. So, huwag na po natin patagalin our first speaker for this activity. Let's welcome Mr. George Justin Mapile Jr. Good morning, sir.
Yes. Good morning po. Maraming salamat po sa pagpapakilala. Naimbag bigat yung amin na po diyan sa Region 1. Maraming salamat sa inyong imbitasyon sa akin sa mahalagang okasyong ito ng Bantay Korapsyon. Webinar on reinforcing public accountability for LGUs and CSOs. Magandang umaga kay Yusek Epimaco Densing Deter, ganoon din sa Region 1 Regional Director Julie Dakiwag.
Good morning, Attorney.
At sa lahat ng mga LGU and DILG officials sa Region 1, magandang umaga. At higit sa lahat, pagbati at magandang umaga sa lahat ng mga CSOs na nakadalo ngayon dito sa ating webinar sa Region 1 at sa lahat ng mga resource person. Good morning po sa inyong lahat. Ang korupsyon po ay malalim ng nakaugat at nakabaon sa lahat ng antas ng burokrasya. Lalo na sa mga LGUs. Mula sa antas lalawigan, munisipyo, antas ng barangay, ang kasalukuyang patronage politics sa bansa na pinipreserba ng mga elite, trapo at oligarkiya ang nagsisilbing matabang lupa para umiral at yumabong sa pinakatalamak na antas ng korupsyon. Sa katunayan, ang korupsyon ay nakaukit na sa kamalayan ng mamamayang Pilipino bilang isang kultura, isang bulok na kultura. Ang epekto nito, sa bawat sentimong ninanakaw mula sa pondong bayan ay katumbas din ng pagliit sa halaga ng natatanggap na serbisyo ng publiko. Sa pinakamalubhang kaso, partisan politics na ang batayan ng pagseserbisyo sa publiko. Kung hindi ka kakampi walang ayuda at serbisyo. Bunga nito, mabilis na binubulok ng korupsyon ng ating mga institusyong politikal, lalo na sa mga LGUs. Ayon kay Deputy Ombudsman Cyril Ramos, sa okasyon ng National Summit on Crime Prevention of the National Police Commission na inilunsad noong August 2019, umaabot sa 1.4 trillion ang nakukulimbat dahil sa korupsyon sa nakalipas na 2 taon, mula sa 2017 hanggang 2018. Sa estimate ng United Nations Development Program or UNDP, noong 2017, mayroong 20% of annual government appropriation ang napupunta sa korupsyon. Ang national budget noong 2017 ay 3.35 trillion pesos. Ang 20% nito ay katumbas ng 670 billion pesos. Ang national budget naman noong 2018 ay 3.76 trillion pesos. Ang 20% na nakulimbat dito ay 752 billion pesos. Ang multibillion na halagang ito na napunta sa korupsyon sa 2 taon na yan ay maaari sanang nagamit sa construction ng 1.4 million social housing units para sa mga maralita. Maaari din sanang nagamit ito sa mga medical or educational assistance o iba pang mga social services para sa 7 million Filipinos annually for that period. Ang sabi ng Ombudsman, Office of the Ombudsman, ang mayroong pinakamaraming na isampang mga reklamo sa kanilang opisina ay nagmumula sa mga opisyales ng mga LGUs noong 2017. Mga gobernador, mga mayor, mga punong barangay at mga kasabwat na kawani ng mga LGU ay umaabot sa 3,189 na kaso ang naisampa sa kanila. Ang kasunod na maraming kasong naisampa sa Ombudsman ay mula naman sa Philippine National Police na umaabot ng 939 na kaso. Busisiin po natin kung saan-saan ba umiiral sa LGU ang korupsyon. Simulan natin sa procurement area. Napakatalamak dito ang procedural lapses. Ang mga paboritong kontraktor at mga supplier ng mga gobernador, ng mga mayor, na mga punong barangay ay karaniwan ay mga dami rin nila ito. Walang public bidding na nagaganap. Umiiral ang mga sweetheart deals kung tawagin. Kung meron man, lutong Macau ito. Pakitang tao lamang. Talamak din ang procurement, sa larangan ng procurement, ang paghingi ng mga corrupt officials na ito ng SOP. Naliliitan na sila sa natatanggap na SOP na 10%. Sa ngayon ay humihingi na sila ng 30 to 60% na SOP sa kabuang halaga noong proyekto na yan. Yun ay sa procurement pa lamang po. Tingnan natin naman sa larangan ng public financial management. Maraming LGU chief executives ang sangkot sa kaliwat kanang kaso ng malversation. Marami rin sa mga LGU top officials ang mayroong patong-patong na unliquidated cash advances. Makakapal ang mukha ng mga ito. Ang ikatlong larangan na umiiral at laganap ang korupsyon ay ang administrative functions. Araw-araw na nasasaksihan ng publiko ang walang kahihiyan ng mga LGU officials na ito ang patuloy na pag-iral ng nepotismo. Nakapwesto sa mga juicy positions ang kanilang mga kamag-anak, kanilang mga asawa, kapatid, mga anak, tatay, nanay. Itinuring ng mga bulok na LGU officials na ito na isang pribadong korporasyon ang poder na inari nila bilang gobernador, bilang mayor o punong barangay. Talamak din ang bureaucratic red tape. Palamuti lamang ang mga nakapaskil na citizens charter sa bawat sanggunian sa lahat ng antas. Hindi ito seryosong naipatutupad. Gayon din, ang use of public vehicles and supplies. Ginagawang personal na service ng pamilya ang mga government vehicles. Pati ang pagsundo ng mga anak sa eskwela, pamamalengke, gamit ang mga government vehicles. Red plate pa man din ang plaka. May ilang kaso pa, pati ambulansya ay ginawang service papunta sa mga beach resort. Bit-bit ang kahong-kahong mga alak. Liban dyan, talamak din ang absenteeism at mga frequent travels bilang junket ng mga officials na ito, lalo na noong wala pang COVID. Lantaran din ang mga ghost projects. Paboritong palabigasan ang farm-to-market road. Tinawag na nila ng mga publiko na ito ay farm-to-pocket road. Hindi rin maawat ang pag-iral ng ghost employees. Inaabuso ang paggamit ng mga JOs or job orders bilang weapon para sa political partisanship. Ang ikaapat na larangan na umiiral ang talamak na korupsyon sa LGUs ay ang legislative authority, lalo na sa sanggunian. Karaniwan ay bypass ang sanggunian sa anumang antas sa lalawigan, munisipyo at lungsod o maging sa barangay. They are entering into contracts without the concurrence of their respective sanggunian. Binabalasubas ang function ng legislative oversight. Baliwala ang sanggunian. Ang ikalima ay ang regulatory functions. Sinasadyang i-delay ang pagtugon sa mga request ng publiko at mga negosyante sa kanilang paghingi ng permit or business occupancy permit. Kung kung walang lagay ay hindi aaksyonan. Kung walang kotong, kung walang suhol, minsan ay ginagamit pa ito na iharas ang requesting party para ibigay ang kanilang hinihinging suhol. Lalo na dito sa Region 1, laganap dito ang quarrying. Sa bawat bayan, karaniwan ay marami ang umiiral na mga illegal quarrying. Kung magkaganon man, nagagamit ang ECC sa pagbibigay ng permit sa kanilang pagkukwari para gawing palabigasan din ang mga permit na ito or tinatawag na environmental permits. Nagaganap din ang illegal operations sa ilang mga corrupt na mga LGU officials. Tampok dito ang pagkakasangkot nila sa illegal drugs operation. On May 2019, President Duterte identified at least 44 mayors and vice mayors as being narcopoliticians rather. Involved din ang mga LGU officials na ito sa illegal gambling. Pasimuno sila sa wedding at iba pang illegal gambling operations. Marami ring kaso dito ang land grabbing case. lalo na may kaugnayan sa operation ng quarry. I-ooperate na lamang ng walang pahintulot ang mga pribadong may-ari ng lupa sa lalo na dyan sa mga gilid-gilid ng mga ilog dyan sa Region 1. Naghahari-harian ang mga LGU officials na ito. Kung gayon, dito ngayon ang pangangailangan na itayo ang Bantay Korapsyon Program alinsunod sa programa ni Pangulong Duterte at pangkalahatang programa ng DILG. Noong August 29, 2018, nilikha ang Bantay Korapsyon Program Management Office at inilaunch ito noong October 2018. Ang Bantay Korapsyon ay isa sa mga pangunahing programa ng DILG. Mayroon itong tatlong component o tinatawag na three-pronged strategy. Isa dito ang pagmumulat, ikalawa ang paghadlang, ikatlo ang pagpigil. Pahintulot niyo pong italakayin ko briefly ang mga component na ito. Ang component ng pagmumulat or education ay upang tiyakin ang mas mataas na pag-unawa ng mamamayan sa mga batas laban sa korupsyon. Noong launching ng Bantay Korapsyon Program, sinabi ni DILG Secretary Eduardo Año, quote, "Let us be part of the movement to eliminate corruption at the local level. Freedom to access information in the LGUs is freedom from corruption." Batay dito, hinihikayat ng Bantay Korapsyon PMO at ng DILG sa kabuuan ang lahat ng mga LGUs sa probinsya, munisipyo at lungsod na ipasa ang isang ordinansa kaugnay sa FOI or Freedom of Information. Naglabas ang PCOO at DILG ng Joint Memorandum Circular noong 2018. Reiteration ito ng Executive Order Number 2, Series of 2016, operationalizing the people's right to information and the state policies of full public disclosure and transparency in the public service. Dapat din na isustina ang full disclosure portal ng lahat ng mga LGU officials. Ang paghadlang, ang ikalawa, or prevention naman, ay para maalis ang mga kondisyon at oportunidad ng korupsyon. Very crucial dito ang role ng mga people's organization, non-governmental organization at mga civil society organizations. Una dyan ang citizens or CSO empowerment. Ang mga CSO bilang partner ng Bantay Korapsyon Program ay dapat regular na mabigyan ng mga kinakailangang pagsasanay para maunawaan ang takbo ng burokrasya at paggogobyerno. Isa ito sa mga trabahong dapat tinitiyak ng mga MLGOO, ng mga CLGO at iba pang DILG officials sa LGU upang maging tunay na kapartner natin sila sa pagsiserbisyo at governance. Ang empowerment sa local governance ay tungkol sa pagpapalawak ng kalayaang matukoy ng mga suliranin at pangangailangan ng mga constituencies at paghahanap ng kaukulang solusyon sa mga suliranin. Ang ikalawa, liban sa empowerment sa mga CSOs na mga hakbang para sa prevention ng korupsyon, ay ang functionality of local development councils. Local development council sa level ng probinsya, city and municipal, down to the barangay levels. 30 taon na po ang lumipas nang ipasa ang Local Government Code na siyang salalayan ng paglikha ng Local Development Council sa mga LGUs. Ang sinasabi sa Section 34, Role of Peoples and Non-Governmental Organization, i-quote ko po ito. Local government units shall promote the establishment and operation of people's organizations and non-governmental organizations to become active partners in the pursuit of local autonomy. Subalit nakakalungkot po mga kababayan dyan sa Region 1, marami ang mga local development council ang pseudo function. Fake ang kanilang operation. Hindi tunay na nag-engage ang mga civil society organizations representing the 25% sa composition ng Local Development Council dahil may ilang mga corrupt officials na manipulated nila ang composition. Ilalagay nila, mag-identify sila ng sarili-sarili nilang sectoral leaders para sila ang ilagay doon sa loob ng People's Council or rather Development Council. Lalo na sa barangay, ang almost 42,000 barangay units natin sa buong bansa ay mga pseudo operations ang takbo ng mga barangay development councils. Hindi nagmi-meeting ang mga executive committee. Ang mga secretariat ng mga development council ay non-functional. Maglalagay sila ng markang 95% excellent or good ang kanilang function for the purpose of reporting. I-report nila sa DILG ang mga fictitious na report. Dito mahalaga ang role ng mga civil society organizations na bantayan ang mga scrupulous LG officials nito sa lalawigan, munisipyo at barangay at i-monitor ang tunay na functionality ng Local Development Council sa buong bansa. Ang ikatlo na hakbang natin para mahadlangan ang korupsyon ay broadening the mechanism for citizens' engagement. At ito ang sinasabi kanina ni Undersecretary Yusek Deter ng formation ng CSO desk directing the provincial, municipal and city councils to establish CSO desk and institutionalize the formation of People's Council. Ito po ay isang broadening component ng participation ng mamamayan para sa paggogobyerno. Hindi sasapat ang 25% representation ng CSO doon sa manipulated operation ng Development Council. At kailangan from there maitayo naman ang another mechanism, broader mechanism, at ito ang tinatawag na People's Council. Ang lahat ng mga civil society organizations sa lalawigan o kaya sa mga munisipyo at lungsod ay hihikayatin natin na maging aktibo sa pag-engage sa paggogobyerno at mailagay sila sa iba't ibang mga local special bodies sa mga kaukulang LGU. Para tunay na maisustina ang Anti-Corruption Initiative, dapat may organisadong network ng lahat ng mga people's organization, ng mga NGO, ng mga CSO sa barangay, city, municipality at provincial levels sa pamamagitan ng pagtatayo ng People's Council. Ang ikatlong strategy ng Bantay Korapsyon ay ang deterrence or pagpigil. Ito ay tukuyin at kasuhan ang mga korap at tiwali na mga government officials sa LGU habang kinikilala naman ang mga tapat at matuwid. Pwede nating i-develop ang karanasan ng Commission on Audit na meron silang tinatawag na procurement watch. Meron din silang tinatawag na participatory audit program. Itong mga CSO ay hinihikayat na buuin ito at maging third-party monitoring organization sila doon sa mga pagpapatakbo at pag-i-implement ng mga programa at aktibidad ng mga LGUs para matiyak natin na naide-deliver sa mga grassroots at mga recipient ang tunay na serbisyo mula sa gobyerno sa halip na gawin nila itong partisan services. Mahalaga dito ang role ng lahat ng mga CSO sa lahat ng antas. Ang sinabi ng Memorandum Circular ng DILG na itayo ang mga mekanism na ito ay patungkol lamang sa probinsya at sa munisipyo at lungsod. Hindi niya inuobliga ang mga barangay councils dito. Pero sa atin, sa punto de vista ng mga civil society organizations, mahalaga rin na ilunsad ang pagtatayo ng People's Council sa mga barangay, lalo na sa mga malalaking barangay sa buong bansa. Nito lamang July 10, nabanggit kanina ni Yusek Densing, naging keynote speaker si Yusek doon sa pagtatayo ng People's Council sa La Union, diyan mismo sa Region 1. Inilunsad sa La Union ng isang provincial CSO assembly at nagpursigi ang mga organizers na itayo ang People's Council kahit na ginigipit sila ng isang LGU sa pagtatayo nito. Tinawag ito ng mga CSO leaders bilang People's Council for Change ng La Union. Guest speaker din ang inyong lingkod diyan bilang nagbigay ng mensahe kaugnay sa Bantay Korapsyon program. Ito po ang tatlong strategy ng Bantay Korapsyon. Yung tinalakay ko na education, prevention, and deterrence. Ilahad ko ng maikli ang framework ng ganitong programa. Inuulit ko rin ang naisalaysay na ni Yusek kanina, ang kaugnay sa participatory governance framework. Ang Bantay Korapsyon program ay based on participatory governance policy framework anchored on the Philippine Development Plan 2017 and 2022. Participatory governance, therefore, is good governance. Ito ang madalas sabihin ni Yusek Densing kaugnay doon sa kung ano ang wasto at balangkas, tamang balangkas ng good governance. Ang good governance, or rather, the participatory governance is all about empowering the citizens to participate in the process of public decision-making that affects their lives. Ano ba ang tinatawag nating good governance? Kung ito ay good participatory governance is good governance, busisiin natin ngayon kung ano ang tamang kahulugan ng good governance. Ang good governance ay tunay lamang kung integral na umiiral ang tatlong mahalagang prinsipyo at component sa pamamahala. Ang una ay ang transparency, ikalawa ang accountability, ikatlo ang people's participation. Kung hindi umiiral ang tatlong mga component na ito ng good governance, ang sinasabi mong governance ay hindi good governance. Isang bogus, isang ampaw, isang salita lamang na walang laman ang kahulugan ng good governance kung hindi kasali ang isa man sa mga component na ito. Himayin natin ang tatlong ito. Ang transparency. Ang bukas at walang ikinukubling pamamahala ang susi sa mga hakbang at reforma laban sa laganap na korupsyon sa mga LGUs. Nagbibigay ito ng lubos na atensyon sa mga sistema at proseso ng pagpapalaganap ng impormasyon para sa mamamayan at kaugnay ng mga usapin, lalo na una, hinggil sa programa, polisiya at patakaran. Ikalawa, hinggil sa kontrata, work programs, project, performance, target at report. Ikatlo, hinggil sa ordinansa at resolusyon ng mga sangguniang panlalawigan, sangguniang bayan o sangguniang barangay. At ikaapat, lahat ng iba pang dokumentong pampubliko kabilang ang SALN o Statement of Assets, Liabilities, and Net Worth. Kakambal, ito pong tinatawag nating SALN, ay karaniwan ay nakatago ito sa publiko. Ayaw ilabas ito ng mga LGU officials or government employees for that matter, na dapat ay kusa nilang inire-report ito taon-taon, every January. Kakambal ng transparency ang malayang akses ng mamamayan sa mga impormasyon. Ang malayang daloy ng mga impormasyon at kaukulang edukasyon kaugnay sa mga ordinansa, resolusyon, regulasyon at programa at aktibidad ng pamahalaan sa LGUs ay fundamental na prinsipyo at alituntunin ng transparency. Ang institusyonal na pundasyon ay kinakailangan para sa mas mataas na antas ng pagtugon ng gobyerno sa paglilingkod sa mamamayan. Kaugnay nito, nararapat ang paglikha ng mga kinakailangang demokratikong mekanismo para maipatupad, mapaunlad o mapataas ang kapasidad ng publiko na tumanggap ng impormasyon at makapagbigay sila ng kaukulang feedback sa mga issue, programa at patakaran na apektado ang kanilang buhay at kinabukasan. At kinakailangan mahikayat natin at makuha ang voluntaryong suporta at partisipasyon ng mamamayan at mga CSO para sa kinakailangang development ng kanilang mga lokalidad. Ang bottom line po, mga kababayan, ang gobyernong walang itinatago ay hindi dapat matakot sa mulat na publiko. Yun po ang unang component ng good governance, ang transparency. Ang ikalawang sangkap naman ay ang accountability. Ulit-ulit na sinasabi natin ito, public office is a public trust. Ang probisyon na ito ng saligang batas ng Pilipinas ay dapat tumalima ang lahat ng mga public officials, halal man siya o appointed. Ngunit nakakalungkot ang realidad. Hanggang salita lamang sila. Wala silang gawa. Ang accountability ay nakatuon sa regular na at napapanahon na ulat sa bayan kaugnay sa lahat ng mga pampinansya at pampublikong transaksyon, lalo na sa mga rekurso ng pamahalaan. Hindi lamang ito isang obligasyon ng gobyerno, kundi gayon din ang mabilis na pagtugon nito sa mga kagalingan at karapatan ng mga mamamayan. Ang pananagutan at maagap na tugon ay matitiyak lamang sa pamamagitan ng makabuluhang partisipasyon ng mamamayan sa komunidad. Ang usapin ng accountability ay hindi lubos na maipatutupad kung walang tunay na transparency. Magkadugtong ang transparency at accountability. Hindi pwedeng paghiwalayin yan para matawag nating mabuti ang paggogobyerno mo. Ang ikatlong component po, mga kababayan, ay ang people's participation. Alinsunod sa balangkas na ang responsibilidad sa pangangasiwa at pamumuno ay common na pinagtutulungan ng namumuno at pinamumunuan. Ang kinatawan ng LGU at civil society organizations ay kapwa magkatuwang para sa mabuting pamamahala. Ang gobyerno at mamamayan ay magkakaroon ng kolektibong responsibilidad para sa kabutihan ng publiko at ng lipunan. Gamitin ang lahat ng mekanismong ito para sa partnership sa pagitan ng gobyerno at mamamayan, tulad ng pagbubuo ng People's Council. Inuulit ko, ang bulok at anti-people, isang bulok at anti-people ang itinuturing ng mga corrupt officials na ito sa governance kung hindi integrated ang tatlong component. Muli, transparency, accountability, and people's participation. Para seryosong malabanan natin ang korupsyon, dapat umiiral ang tatlong yan. Bilang pangwakas, ipahintulot niyo po na bigkasin ko ang isang sipi mula sa talumpati ni Yusek Epimaco Densing Deter noong October 2018 sa okasyon ng Bantay Korapsyon Program launching. Quote, the most important portion of the Bantay Korapsyon Program is to let the people be part of the whole program, and this is what we call the participatory governance. The fight against corruption by government will be useless until and unless the people are involved in the whole process of attacking or reducing corruption in our respective local government unit. Unquote. Mga kababayan diyan sa Region 1, panawagan sa mga CSOs at mga mabubuting LGU officials at DILG officials. Sama-sama nating bantayan, ilantad at i-report ang mga anomalya, katiwalian ng mga opisyales ng gobyerno sa kapitolyo, sa munisipyo, sa city hall at sa barangay. Ilunsad ang isang citizens movement type of organization against corruption sa pamamagitan ng pagtatayo ng People's Council sa lahat ng antas. Pangungunahan ng mga People's Council at iba pang mga CSOs ang pagdokumento ng mga reklamo at ipadala ito sa email sa bantaykorapsyon.dilg@gmail.com. Ilakip ang salaysay, picture or video bilang mga ebidensya. Pwede ang anonymous. Banggitin nyo na pwedeng hindi isama ang inyong mga pangalan. Maaari at hinihikayat nating ang mga CSO mismo ang magsampa ng reklamo. Maaari ding ipadala ang reklamo laban sa anomalya at korupsyon sa Bantay Korapsyon Team sa Region 1. Meron tayo masisipag na mga leader dyan sa pamamagitan ni Attorney Lawrence Patrick. Siya ang Bantay Korapsyon Regional Legal Officer at ang kanyang kabady na si Sosimo Baruelo Jr., ang ating Bantay Korapsyon Regional Coordinator. Kapartner ng DILG sa pagpapatupad ng programang ito ang mga people's organization, non-governmental organization, at iba pang mga social organization, CSO, kabilang dyan ang mga civic organization, Rotary, Lions Club, at iba pa. Mga social movement, ganon din ang mga kooperatiba, ang mga professional at business groups, at iba pang mga CSOs. Ang voluntaryong partisipasyon ng mga CSO at mamamayan sa programa ng Bantay Korapsyon ay ekspresyon ng kanilang kolektibong pagnanais na mapuksa ang iba't ibang anyo ng korupsyon upang makamit ang isang lokal na gobyerno na matino, mausay at maasahan. Puksain ang mga korap. Magandang umaga po sa inyong lahat. Maraming salamat po.
Maraming salamat po, Sir George Mapile Jr. sa inyong napakagandang mensahe po sa pagpapakilala ng Bantay Korapsyon Program at kung paano po puksain ito. Ayan, so tingnan natin kung nakikinig nga po ba ang ating mga participants. Paki-type sa chat box kung masasagot nyo po ito. Isa sa mga na-mention ni Sir George. Sige, ang sabi kasi, participatory governance is good governance. So ano po yung tatlong components ng good governance? Yung maunang sasagot sa chat box, may premyo mula kay Attorney Patrick. Ayan, may nakita akong unang sagot from Tayug. Ang sabi, transparency, accountability, and people's participation. Palakpakan po natin sila. Nakikinig po. Kasama natin from Tayug. Thank you again, Sir George, for that. And let's move on po to our next session. By the way, na-share na po sa ating, ayan, ang dami pa rin sumasagot. Ibig sabihin talaga, sir, nakikinig sila kanina. Maraming salamat po. Ayan, dyan si Bawang, Umingan, San Nicola, ay ano pa to, mga, ayan, hindi ko na po mabasa, ang bilis-bilis, Kalasyaw, ayan po. So, before we move forward pala sa ating second speaker, na-share na po sa ating chat box kanina yung ating pre-assessment. So, sagutan na lang po natin and ayan. Siguro Sir Leo, paki-ano po ulit, pa-send po ulit ng ating link para makita ulit. Natabunan na, ang dami kasi, ang dami-daming sumagot. Maraming salamat po. Okay. So for our session 2, we will be discussing RA 019 and RA 7080, its salient features, the grounds, and rules. So before we present to our next speaker, so let me do the honors in introducing our next speaker. Our guest lecturer for this day hails from Balungao, Pangasinan. He is the son of Roberto Lapuz Rivera and Melinda Luna Sison, and he has always emphasized that he is happily married to his wife, Chris Maine Rivera, to whom he has 2 children, Gabriel Lucas and Celine Athena. For his educational background, he has finished his elementary education in Balungao Central School, Balungao, Pangasinan, as class valedictorian. His secondary education at St. Anthony Abbot Academy, Villasis, Pangasinan, and he graduated with honorable mention thereat. Thereafter, he completed his degree in AV Political Science as a cum laude from St. Louis University. He finished his Bachelor of Laws in the same university on 2013, took the Philippine Bar on the same year, and passed the same. He also took his Master's in Development Management, major in Public Management at Pangasinan State University, Urdaneta City Campus in 2019. In pursuit of further excellence, he completed his basic investigation training course during the 47th Agents and 18th Special Investigators Basic Investigation Training course at the National Bureau of Investigation Academy, Baguio City. And he also graduated as class valedictorian. He has unceasingly pursued further higher education through trainings and schooling in notable and prestigious educational institutions in the country. Notable in his certification course on Corporate Security Management, CCCSM 2019-2 at the National Defense College of the Philippines, Department of National Defense, Camp Aguinaldo, where he ranked second in his class. Wow. In the same prestigious military educational institution, he graduated and became a part of the 26th Executive Course in National Security, or the ECNS. He began his legal profession as an investigation agent of the National Bureau of Investigation. His previous work assignments in the NBI included Anti-Graft Division, Internal Affairs Division, Security and Management Division, and Ilocos Regional Office. Thereafter, he transferred to the Cooperative Development Authority as an Attorney 3. At present, he is the Chief of the Regional Investigation Unit of the National Police Commission Regional Office 1, Concurrently, he is the Provincial Officer of Ilocos Norte. A well-sought lecturer in the field of law and criminal investigation. Join me in welcoming our guest lecturer, Attorney Philip Raymond S. Rivera. Good morning, sir. Hello, attorney. Magandang umaga po.
Naririnig na po? Am I loud and clear na?
Yes, sir. Loud and clear.
May I be allowed to share my screen po? Nakikita na po yung screen?
Yes, sir. Kita na po.
Okay. Again po, maraming salamat sa very generous introduction, ma'am. Before I begin, I'd like to greet each and everyone po muna, to all participants in today's Bantay Korapsyon webinar, to our colleagues in the DILG, fellow public servants, representatives of the private sector. Isang mapagpalang araw na imbag nga aldaw kada tayo amin na po. A pleasant morning, ladies and gentlemen. Okay. It has always been a privilege for me to do a lecture on certain subject matters. Sabi nga dyan po sa inyo, sa nakikita sa inyong mga screen now, when you teach what you love and share what you know, you open eyes, minds, hearts, and souls to unexplored worlds. Considering our topic for today is the Anti-Graft and Corrupt Practices Act of 1960 and other related laws, it necessarily follows that I will do my best to open your eyes, your hearts, and souls to corruption. I'm just kidding. Kidding aside, what I really mean is let us together explore, learn, and understand legislations pertinent to alleviating, stopping, curtailing, and or ending corruption in our beloved country. And I hope after the lecture, I will also learn through your questions, suggestions, interactions, and or sharing. Sabi nga sa screen ninyo, when you teach, you learn. I might also learn new techniques. I might also learn new techniques from you considering veteran corruption. Ano po yung techniques na yun? Techniques in corruption. No, just kidding again. I mean, other ways and means in combating corruption. There you go. So, ladies and gentlemen, let's begin. Okay. It is most respectfully opined that there is no other provision of law more fitting and appropriate to start this lecture other than what is provided under Article 11, Section 1 of the 1987 Philippine Constitution, which provides that public office is a public trust. Public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. We as public servants are beholden to always uphold and prioritize public interests over our own interests and self-aggrandizement. In a nutshell, ang ibig nating sabihin, this provision of the supreme law of the land encapsulates any and all existing anti-graft and corrupt legislations in the country. Okay. On your screen is the outline of our discussion for today. First, we will try to define graft and corruption. Next, we will proceed to the nitty-gritty ng ating subject matter for today, the Anti-Graft and Corrupt Practices Act of 1960. Thereafter, we will proceed, medyo baliktad to. We will proceed to plunder law, then malversation under the revised penal code, then Q&A. Moving on, let us try to define graft and or corruption. You know, ladies and gentlemen, sa pagkadami-dami ng pwede nating ma-enumerate na legislation regarding anti-graft and corruption, wala ni isang batas ang nagbigay ng nagbigay ng exact definition on what is graft and or corruption. The terms graft and or corruption is not expressly defined by any legislation in the Philippines. In the Philippine setting, the term graft lacks an exact legal definition. The Anti-Graft and Corrupt Practices Act of 1960 merely enumerates a number of punishable corrupt practices of public officers, while the Code of Conduct and Ethical Standards of Public Officials declares as unlawful certain prohibited acts and transactions. Saan pa ba sanang batas pwede natin hanapin ang exact legal definition ng graft and corruption? Napakarami, sabi ko nga. Tignan natin. Yan. There's a plethora of law na sana pwede nating makita yung exact definition. You have there the Constitution, the Ombudsman Act of 1989, RA 1379, an act declaring forfeiture in favor of the state any property found to have been unlawfully acquired by any public officer or employee, and providing for the proceedings therefore. RA 6713, the Conduct and Ethical Standards for Public Officials and Employees, its implementing rules and regulations. You also have their Title II and Title VII of the Revised Penal Code, crimes against the fundamental laws of the state, crimes committed by public officers, PD 46, which makes it punishable for public officials and employees to receive and for private persons to give gifts on any occasion, including Christmas, PD 749, RA 7080, the plunder law, and PD 1606 as amended by RA 7975 and RA 8249. Okay, we have the Sandigan Bayan Law. Hayan, napakarami, but none of which made a definite legal definition on what graft and or corruption. Bakit nga ba? Bakit nga ba napakarami nating batas regarding graft, combating graft and corruption, pero wala man lang ni isa sa kanila ang nag-define on what is graft and corruption? Okay, let's proceed. Let's answer. In a book with the subject matter graft and corruption, you see the title on your screen, the title of the book, and the author. It was explained that generally, courts and laws do not give a clear-cut definition of the terms graft and corruption, considering the extreme difficulty to contain all the elements of the different types of graft or corruption in one sweeping generalization. Each case, sabi dun sa book, each case must be evaluated on the basis of its own facts. Masyado daw kasing maraming klase ng graft and corruption, and the proper way to define each is a case-to-case basis. In the said book, in-enumerate niya lahat ng klase ng korupsyon na lumabas sa history ng Pilipinas. However, it would be very lengthy kung iisa-isahin natin. Okay, moving on. Still on defining graft and corruption. Although not pertinently defined by legislation, the term graft, however, was defined by the Career Executive Service Board through its resolution number 559, amending the existing board policy on conferment of career executive service eligibility to applicants with pending cases. Okay, paano na-define ang term na graft sa issuance na ito ng CES board? Sabi ng CES board, graft is the acquisition. Graft is the acquisition of gain or advantage. Acquisition of gain or advantage by dishonest, unfair, or, remember this term, or sordid means. Sordid means especially through the abuse of his position or influence in politics, business, etc. Can you just imagine the adjectives used? Parang hindi na person yung dinidescribe. Dishonest na nga, unfair pa, sordid at abusive pa. Napaka-evil ng taong gumagawa ng graft. Emphasis is given to the adjective dishonest as it will appear again and again from time to time sa ating lecture. Moving on to the meaning of corruption. Corruption, on the other hand, has been sociologically defined as the misuse of entrusted power for private benefit. So one is given authority or power, then misuse it. Entrusted by the people, misuse it for private benefit. In a bigger sense, both the terms graft and corruption are synonymous and therefore interchangeable. Since wala namang specific na batas nor declaration ng ating Supreme Court sa specific definition ng graft and or corruption, they are interchangeable. Okay, moving on to our main topic, Republic Act number 3019, otherwise known as the Anti-Graft and Corrupt Practices Act of 1960. Itong taong ito, hindi pa nagkakakilala ang aking mga magulang, hindi pa nila ako na iisipang buuin. So maybe, mas maraming nakaka-relate sa inyo dito. Nonetheless, let's proceed. Congress in 1960, specifically, nakalagay dyan sa inyong screen, August 17, 1960, Congress in 1960 enacted the Anti-Graft and Corrupt Practices Act to deter public officials and employees from committing acts of dishonesty. Yan, lumabas na naman si dishonesty. And improve the tone of morality in public service. It was declared to be the state policy in line with the principle that a public office is a public trust. To repress certain acts of public officers and private persons alike which constitute graft or corrupt practices or which may lead thereto. This is so declared in a 1968 decision of the Supreme Court in Morphe versus Mutok et al. Yung purpose, yung reason bakit na-enact ang RA 3019 noong August 17, 1960 ay dineclare mismo ng Supreme Court in this 1968 Morphe versus Mutok et al. Case. Congress believed that Filipinos are prone to dishonesty. Dishonesty naman. I would like to be emphatic on that. Filipinos are prone to dishonesty. Hence, the Congress enacted this Anti-Graft and Corrupt Practices Act of 1960. On my part, ladies and gentlemen, to be fair naman, on my part, I have always personally believed that Filipinos are honest naman, hindi po ba? I hope you agree on that with me. Sadly, that is my personal belief. And remember, ladies and gentlemen, sabi ng Congress, Filipinos are prone to dishonesty. I am a Filipino. Moving on. Okay. Anyway, how will the said law deter the foreseen acts of dishonesty of public officers? Okay. How will RA 3019 deter acts of dishonesty? Accordingly, Republic Act 3019 or the Anti-Graft and Corrupt Practices Act of 1960 has the most comprehensive enumeration of corrupt practices of public officers. In-enumerate niya yung maituturing na practice of graft and corruption. In this way, specific graft and corruption acts are punished accordingly. Highlighted ang term na public officers. Kulay red po siya dyan sa screen niyo. Bakit? Because under the said law, the following are the persons covered. All public officers. Number one, highlight po yan. All public officers of the government. Pero may number 2 rin po. Any person who will commit the enumerated unlawful acts under this law. Focus lang tayo muna at the moment doon sa all public officers of the government. Actually po, sa batas, dinefine kung sino ang public officer. However, it does not necessarily mean na kung ikaw ay private individual, hindi ka na pwedeng kasuhan under RA 3019 or kung ikaw ay private individual, hindi mo na pwedeng ma-violate ang RA 3019. Specific yan under Section 9 of the said law na pwede private individuals can be held criminally liable under this law. Focus muna tayo sa term na public officers. Since karamihan po sa atin na present ngayon attending this webinar are public officers. Okay, who are included in the term public officers? Section 2 of RA 3019 provides that public officers include elective and appointive officials and employees, permanent or temporary, whether in the classified or unclassified or exempt service, receiving compensation, even nominal, kahit na hindi fixed, even nominal from the government. The term public officers embraces every public servant from the highest to the lowest rank. All public servants from the President of the Republic of the Philippines down to the garbage collector, if employed and paid by the government, come within the term of a public officer. And klaro po tayo dyan. Yan. In one decision of the Supreme Court, the coverage on who is considered a public officer is further elaborated. Sabi sa isang decision ng Supreme Court, aside from what has already been defined under Section 2 of RA 3019, public officer shall also include one who is taking part in the performance of public functions in the government or performing in said government or any of its branches public duties as an employee, agent, or subordinate official of any rank or class. Here is the gist of the case. Tignan natin. Ito mismo yung case. Javier was charged with malversation of public funds. She was the private sector representative. Naka-highlight po yan. Private sector representative in the National Book Development Board, NBDB. Buti nga po hindi napalitan yung NBSB. Buti nang naging no boyfriend since birth. Anyway, she is a private sector representative of the NBDB, which was created by RA 8047, otherwise known as the Book Publishing Industry Development Act. So, nakasuhan siya ng malversation of public funds. Now, kung nakasuhan ka ng malversation of public funds, tendency is liable ka rin under the special law, under this special law RA 3019. Ang pinakatanong dito, is Javier even though a private sector representative to the board, the NBDB, considered a public officer? Yes, the answer is yes. Javier is a public officer, notwithstanding that Javier came from the private sector to sit as a member of the NBDB. The law invested her with some portion of the sovereign functions of the government so that the purpose of the government is achieved. In this case, the government aimed to enhance the book publishing industry as it has a significant role in the national development. Hence, the fact that she was appointed from the private sector, and not from the other branches or agencies of the government does not take her position outside the meaning of public office. Although she is a representative of the private sector to the board, National Book Development Board, she is endowed with public authority, receiving compensation through public funds. Therefore, she is a public officer. And moving on. At this juncture, maliwanag na sa atin ang meaning ng public officer. Balikan natin yung coverage ng RA 3019. Okay. All public officers of the government. All public officers of the government. What is then meant by the term government in the said definition? Okay. As seen in your screen, government includes national, local governments, government-owned and controlled corporations, instrumentalities, agencies, or branches of the government. And moving on to the nitty-gritty of our today's subject matter. Okay, what are the punishable acts under Section 3 of RA 3019? Section 3 of RA 3019 provides that in addition to acts or omissions of public officers already penalized by existing law, the following shall constitute corrupt practices of any public officer and are hereby declared to be unlawful. Isa-isahin na natin yung mga prohibited acts under RA 3019 and let's discuss one by one. Okay. First paragraph. Persuading, inducing, or influencing another public officer excuse me, to perform an act constituting a violation of rules and regulations duly promulgated by competent authority or an offense in connection with the official duties of the latter, or, second part niya to, allowing himself to be persuaded, induced, or influenced to commit such violation or offense. Himayin natin. Persuading, inducing a public officer, persuading, inducing, or influencing another public officer to do what? To perform an act, to perform an act constituting a violation of the rules and regulations duly promulgated by competent authority, or to perform an offense, to do an offense in connection with the official duties of the latter. And magbigay tayo magbigay tayo ng example. Magbigay tayo ng example. If you remember the ZTE NBN project. Yan. If you remember, since this is a review, sabi kanina sa ating introduction, example is the alleged act of former COMELEC Chairman Benjamin Abalos in allegedly bribing Romulo Neri with the amount of 200 million pesos in exchange for the approval of the NBN project. This is so narrated in the Neri versus Senate Committee on Accountability of Public Officers and Investigation, GR number 180643, March 25, 2008. Yan. Ano ba ang nangyari dito sa kaso? Romulo Neri, then Director General of the National Economic and Development Authority, NEDA, was invited by the respondent Senate committees to attend their joint investigation on the alleged anomalies in the National Broadband Network NBN project. This project was contracted by the Philippine government with the Chinese firm Zhongxing Telecommunications Equipment, ZTE. I hope I pronounce it right. Which involved, which involved the amount of 329,481 to 90. 329,481 290 US dollars. Yan, ganun kalaki. More or less amounting to 200 million. Yan. When Romulo Neri, testified before the Senate committees, he disclosed that then COMELEC Chairman Benjamin Abalos, brokering for ZTE, offered him 200 million in exchange for his approval of the NBN project. Pinalabas to sa TV, public knowledge to. Romulo Neri further narrated that he informed PGMA President Gloria Macapagal Arroyo about the bribery attempt and that she instructed him not to accept the bribe. However, when probed further on what they discussed about the NBN project, Romulo Neri refused to answer anymore. After niya magsabi, spontaneously declaring that there was a bribery attempt, nung sumunod na hearing at tinanong siya, sabi niya, I invoke my right on executive privilege. Sabi niya, lahat ng sagot niya ay sakop ng executive privilege. Therefore, hindi niya pwedeng i-disclose. In particular, he refused to answer the questions whether or not President Gloria Macapagal Arroyo followed up the NBN project, whether or not President Gloria Macapagal Arroyo directed him to prioritize it, and whether or not she directed him to approve it. The Supreme Court in a divided decision, 9-6, very close. The Supreme Court in a divided decision, 9-6, 9 declaring that communication is part of the executive privilege. Yun lang. Hindi na pinag-usapan pa kung may liability under RA 3019. Kaya nga, I use the word alleged acts. Okay. Moving on to the next prohibited act. Okay. Next, directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself or for any other person in connection with any contract or transaction between the government and any other party, wherein the public officer in his official capacity has to intervene under the law. Okay. Ayon sa prohibited act na ito, bawal humingi or tumanggap ng regalo. Requesting or receiving ang bawal. Both. Requesting or receiving ay bawal. The term used is or. Meaning, sakop ng Section 3B, itong provision na to, both ang paghingi o pagtanggap ng regalo. Sino ang bawal humingi o tumanggap ng regalo? Si public officer. Kung ang dahilan ay patungkol sa kontrata o transaksyon sa gobyerno, kung saan si public officer involved ay may karapatang makialam o mag-intervene sa nasabing transaksyon o kontrata. E paano kung ibang tao ang binigyan ng regalo? Pasok pa rin yan under this paragraph. Bakit? Kasi ang sabi sa provision, for himself or for any other person. Any other person. Eh ano naman yung gift na binabanggit dyan? Okay? Ano yung gift or present na binabanggit dyan? Share, percentage, or benefit. Anything of value. Anything of value, ladies and gentlemen, may monetary value. Kaya nga, lagi nating tatandaan, under Section 3B, hindi kasama ang inyong mga nobyo, nobya, o kaya mga asawa. Bakit? Because they are considered priceless. Next. Okay. 3C, paragraph C. Directly or indirectly requesting or receiving any gift, present, or other pecuniary or material benefit for himself or for another from any person for whom the public officer in any manner or capacity has secured or obtained or will secure or obtain any government permit or license in consideration for the help given or to be given. Yan. Kanina, sa paragraph B, ang involved ay contract or transaction with the government. Wait, we are in paragraph C. Ngayon naman, ang transaction involved ay issuance ng government permit or license. This is a special form of bribery as provided under Article 210 of the Revised Penal Code. Because of the public officer's authority, influence, or help in issuing government license or permit from his office, he, the guilty public officer, he requests or receives anything of value from the person securing or has secured said government license or permit. Okay, para mas lalo nating maintindihan. Case in point, Lucman versus People of the Philippines, March 18, 2019. Yan, mainit-init pa, bago pa tong kasong to. Ano ba ang nangyari dito? This is a petition for review on certiorari or certiorari for others under Rule 65 questioning the conviction of Lucman by the Sandigan Bayan. The Supreme Court pronounced, sabi ng Supreme Court, basahin natin, after a judicious review of the case, the Supreme Court, is convinced that the Sangguniang Bayan, that the Sandigan Bayan correctly convicted Lucman for violating Section 3, Paragraph C of RA 3019. It is undisputed that Lucman was a public officer at the time the offense was committed. He then being the OIC Regional Executive Director of the DENR Region 12. As the OIC read, Regional Executive Director, he had the authority to grant applications for free patents such as the ones filed by private complainants. Ano bang nangyari? By evidence, it was established that Lukman demanded 2.5 million pesos and actually received 1.5 million from private complainants. And these amounts were for what purpose? For and in consideration of the grant of their applications for free patents of their lands. Sabi ng Supreme Court, in view of the foregoing, the court finds no reason to overturn the Sandigan Bayan's findings as there is no showing that it overlooked, misunderstood, or misapplied the surrounding facts and circumstances of this case. And considering further the fact that it was the best position to assess and determine the credibility of the parties' witnesses. As such, Lukman's conviction for violation of Section 3, Paragraph C, must stand. Ano ang naging penalty? Mabigat. Considering Lukman was already nasa peak na siya ng kanyang career, 6 years and 1 day to 9 years of imprisonment with the accessory penalty of perpetual disqualification to hold office. Ulitin natin para hindi pa marisan. The penalty, 6 years and 1 day to 9 years of imprisonment with the accessory penalty of perpetual disqualification to hold public office. Lesson of the case. Kung mangungontrata ka at lalo't milyon ang bayad, mag-comply ka on your end. Ano bang nangyari dito? Ayun, almost 2 years after magbayad ni complainants, wala pa ring na-release or na-issue na patent ng lupa ni na complainant. Kidding aside. The lesson is, as public servants, ladies and gentlemen, we must shun away from any bribe that is against the law. We just do our job on the basis of our job description and with the guidance of existing and prevailing laws, rules, and regulation. Moving on. Paragraph D, Section 3, Paragraph D provides as unlawful the act of accepting or having any member of his family accept employment in a private enterprise which has pending official business with him during the pendency thereof, or within 1 year after its termination. Okay, himayin natin. Si public officer accepted or having any of his family member accept any employment in a private sector, and such private sector has a pending official business with the public officer or his office. And the employment, when was the employment accepted? During the pendency of the transaction or within 1 year after the termination of said transaction. Medyo madaling intindihin itong paragraph. Next, yan. Section 3E is considered as a bar exam favorite question, favorite topic. Ang dami, ilang beses yan lumabas sa bar exam as per review. Okay, what is it? Causing any undue injury to any party, including the government, or giving any private party any unwarranted benefits, advantage, or preference in the discharge of his official, administrative, or judicial functions through manifest partiality. Okay? Through manifest partiality, evident bad faith, or gross and excusable negligence. Okay. I was informed before tayo mag-proceed, magkaroon muna tayo ng 5 minutes na CR break, water break. We will stop from here. After 5 minutes, 10:35, balik tayo.
Okay po, thank you, Attorney Philip. 5 minutes CR break po sa ating lahat. Thank you.
Ano ba? Okay lang? 5 minutes break? Well, kaya. Or medyo pasok mo dito. Itakto-takto lang. Sige. Tingnan mo na ako, nung mapunta din ako sa tapos. Wait, sige. Okay.
Andyan pa si Yusek. Hello?
Hello, sir, ulit.
Yes, can we already proceed?
Yes, sir. Pwede na po. Thank you.
Okay. We are here in this paragraph, in paragraph E. Sabi natin kanina, bar exam favorite ito. Lagi itong lumalabas sa mga nakalipas na bar exam. Himayin natin, the elements. What are the elements? The public officer discharging administrative, judicial, or official function must have acted with manifest partiality, evident bad faith, or inexcusable negligence, and that his action caused, dalawa ang naging cause, any undue injury to any party includes the government, or his action caused, the cause, ang naging cause ng action niya, giving any private party unwarranted benefits, advantage, or preference in the discharge of his function. Take note that since bad faith is an element, good faith and lack of malice becomes a valid defense in this paragraph. Okay, let's have a simple mental exercise. In violation of Section 3E, RA 3019, okay, causing any undue injury to any party, including the government, and giving any private party any unwarranted benefits, must both circumstances be present to convict the accused of the crime. Kailangan ba present yung dalawang naging cause ng evident bad faith or manifest partiality or inexcusable negligence ni public officer? Kailangan ba yung binanggit kong dalawa kanina, yung injury to any party including the government, or that nagkaroon ng unwarranted benefits, advantage, or preference yung one party to the disadvantage of another? The answer is no. The Supreme Court has clarified that the use of the disjunctive word or connotes that either act of causing any undue injury to any party, including the government, and the next one, giving any private party any unwarranted benefits, advantage, or preference, qualifies as a violation of Section 3E of RA 3019 as amended. The use of the disjunctive or connotes that the two modes need not be present at the same time. Kaya nga mode siya. In other words, the presence of one would suffice for conviction. This is so declared in the case of Alvarez versus People of the Philippines, June 29, 2011. Okay. For us to better understand, let us review. Balikan natin ito. Marami ang halos lahat siguro tayo ito. Alam natin kung ano to. Engineer Ricardo L. Santillano versus People of the Philippines, March 3, 2003. Yan. Very controversial case. This is the case of Ruben B. Ecleo Jr. Yan. Pangalan pa lang, alam nyo na yung kaso. Arsenia N. Orejas and Anadelia N. Navarra, all public officers being the municipal mayor, municipal treasurer, and municipal planning and development coordinator, respectively, of San Jose, Surigao del Norte. All three accused facilitated the release of public funds in favor of Engineer Ricardo Santillan, the contractor, okay, involving construction projects of the San Jose Surigao del Norte. In the said case, the public fund released was described as way higher than the actual cost of accomplishment of the project constructed by Engineer Santillano. Para mas ma-appreciate natin, tignan natin ano-ano yung mga project na yon. Yan. It is flashed on your screen, in your screen. right now. Una, construction of the public market of the LGU concerns, San Jose, Surigao del Norte. Release fund amounted to 4,008,005 pesos. Project accomplishment was only equivalent to 3,563,247.83 pesos, thereby giving unwarranted benefits, advantage, or preference to Ricardo L. Santillan and causing undue injury to the government in the total amount of 444,575.17. Next project, municipal building public fund released amounted to 3,949,664 pesos. The contract price was only, mas maliit pa ngayong contract price, 3,684,575. And despite the fact that the project accomplishment was only pegged at 37.38% or equivalent to 1,437,024.30, thereby giving unwarranted benefits, advantage, or preference again to Engineer Ricardo L. Santillan, causing undue injury to the government in the total amount of 2,412,639.7. Pangatlo, repair of the building of PBMA Women's League, a private organization amounting to 300,000 pesos, thereby giving unwarranted benefits or advantage or preference to the PBMA Women's League and causing undue injury to the government in the total amount of 300,000. Yan. Yan ang Engineer Ricardo L. Santillan versus People of the Philippines. Now, ano ang hatol ng Supreme Court? Sa hatol ng Supreme Court, all are guilty, including Engineer Santillano, a private individual, not a public officer. Why? Because sabi nga natin kanina sa coverage, under Section 9 of RA 3019, it is expressly provided that private individuals who commit any of the enumerated unlawful acts herein are also criminally liable under this law. Okay, let's move on to the next paragraph. Neglecting or refusing after due demand or request without sufficient justification to act within a reasonable time on any matter pending before the public officer. On any matter pending before the public officer. Okay, himayin natin. The public officer neglected or again ang ginamit, neglected or refused to act without sufficient justification after due demand or request has been made on him. So there was neglect to perform or refusal to perform without sufficient justification and only after demand or request has been made upon the public officer. Reasonable time has elapsed from such demand or request without the public officer having acted on the manner pending before him. And such failure to act is for the purpose. Ano ang purpose? Bakit mayroong neglect or refusal to perform the duty of the public officer? Such failure to act is for the purpose of obtaining directly or indirectly from any person interested in the matter, pecuniary or material benefit or advantage. Favoring his own interest ni public officer kasi may personal interest siya. Inuna niya ang kanyang personal interest kaysa sa public interest which is performing his job, or giving undue advantage in favor of or discriminating against any other interested party. Take note, ladies and gentlemen, that the neglect or delay of public function must be accompanied by an express or implied demand of any benefit or consideration for himself or another. Absent such demand, the officer shall be merely administratively liable. Of course, separate criminal liability pa kung ito ang nakomit. May separate criminal liability pa under the revised penal code, the anti-red tape law as amended by RA 11032, or the Ease of Doing Business and Efficient Government Service Delivery Act of 2018. That is paragraph section 3, paragraph F. Moving on. Okay. Next is entering on behalf of the government into any contract or transaction manifestly and grossly disadvantageous to the same, whether or not the public officer profited or will profit thereby, irrespective of profit, immaterial kung may kinita or may advantage na nakuha ang public officer. Okay, himayin natin what are the elements. The public officer entered into a contract or transaction on behalf of the government. And such contract or transaction is grossly and manifestly disadvantageous to the government. Itong second element or last element is the threshold of the crime. Dito natin sinasangguni kung nakumit ba itong section 3 paragraph G. Ulitin natin. The public officer entered into a contract or transaction on behalf of the government, and such contract or transaction is grossly and manifestly disadvantageous to the government. Okay. Examples here include irregularities done in the procurement of government equipment. Okay. Say, for example, the Department of Agriculture, just an example, contracted a supplier for the purchase of certain biochemical fertilizer. Said office, for example, again, spent 1 million pesos for the contract. After evaluation, the Commission on Audit found out that the price should have only been 800,000, or that there are other brands with the same quality but of a way lower price, leading to the threshold of the crime, which provides that the transaction or contract is grossly disadvantageous to the government. That is section 3, paragraph G of RA 3019. Moving on. Section 3, paragraph H. Yan. Having excuse me. Having financial or pecuniary interest in any business. Having financial or pecuniary interest in any business, contract, or transaction in connection with which he intervenes or takes part in his official capacity, or in which he is prohibited from having any interest. Yan. Himayin natin. Himayin natin. Directly or indirectly having financial or pecuniary interest in any business, contract, or transaction in which the public officer intervenes or takes part in his official capacity. Intervention. Take note, ladies and gentlemen, that intervention here must be actual and in the official capacity of the public officer. Ulitin po natin, yung pag-intervene ni public officer must be actual and in the official capacity and in his official capacity. Or yung pag-intervene niya is prohibited by the Constitution or by law from having any interest Meaning yung pag-intervene niya or pagkakaroon niya ng interest, personal interest sa any transaction or business na binabanggit dito is prohibited by the Constitution or by law. This is a case of conflict of interest where the public officer who is financially interested in a certain business uses his authority and intervenes, or where he is legally prohibited by law to do so. Para mas maintindihan natin itong ibig sabihin ng Section 3, Paragraph H, tignan natin yung mga examples. Yan, case in point. Case in point. Yung una, first bullet. The Sandigan Bayan has found former Carmen Bohol Vice Mayor Josil Trabajo guilty beyond reasonable doubt of violating Section 3H of RA 3019 or the Anti-Graft and Corruption Act. The Anti-Graft Court sentenced Trabajo to suffer the penalty of 6 to 10 years imprisonment with perpetual disqualification from holding public office. The Sandigan Bayan appreciated the evidence of the Ombudsman showing that Trabajo, ganda pa naman ng pa-apelyado ni Mayor, Trabajo in his official capacity as presiding officer of the Sangguniang Bayan of Carmen Bohol, excuse me. The Sandigan Bayan appreciated the evidence of the Office of the Ombudsman showing that Trabajo in his official capacity as presiding officer of the Sangguniang Bayan had financial or pecuniary interest in the implementation of the municipality's farm-to-market road projects back in 2003. Nabanggit ito kanina ng ating first speaker. Evidence showed that last October 2000, Trabajo instructed the Sangguniang Bayan to pass 2 resolutions to fast-track the implementation of barangay road projects covering the areas of Vallehermoso, Montehermoso, and Luan La Salvacion of their municipality. Ito ang masaklap. Trabajo admitted that in 2003, he supplied limestone called Anapog and was paid 75,150 pesos for 501 loads for the municipality's projects. In its decision, the Sandigan Bayan gave no credence to Trabajo's defense. Anong naging defense? Trabajo, sabi ni Trabajo, he did not benefit from the transaction because he was paid only a year after. And that the Sandigan Bayan also ruled that failure to show that he, Trabajo, profited from the transaction would not necessarily result in acquittal if under this paragraph. Sabi nga, di ba? Profit is not an element of this specific paragraph. Neither can he, sabi rin ni Sandigan Bayan, neither can he be exonerated from culpability by arguing that it was Engineer Gudia, municipal engineer, who suggested that Trabajo supply the Anapog instead because as vice mayor, he was a local government official who should have known the rules and prohibitions with regard to conflict of interest. The foregoing facts were also relatively similar to the case of Jaime H. Domingo versus Sandigan Bayan, October 25, 2010. Dito sa unang case kay ex-Vice Mayor Josil Trabajo, siya ay presiding officer ng Sangguniang Bayan. In the second case, similar facts. Nagkataon lang na ang nag-deliver ng buhangin, graba, just like the limestone of Vice Mayor Trabaho ay si Mayor Jaime Domingo naman. Okay. So these are the cases in point under paragraph H, section 3, paragraph H, ladies and gentlemen. Moving on, paragraph I, directly or indirectly becoming interested for personal gain or having a material interest in any transaction or act requiring the approval of a board, panel, or group of which the public officer is a member and which exercises discretion in such approval, even if the public officer does not vote against the same or does not participate in the action of the board, committee, panel, or group. Okay? Himayin natin. Directly or indirectly becoming interested for personal gains or having material interest in any transaction or act which, dalawa po yan, requires the approval of a board, panel, or group of which the public officer is a member and which exercises discretion in such approval. Next, even if he votes or does not participate, even if he does not vote or does not participate in the action of the board, committee, panel, or group. Take note that interest for personal gain shall be presumed against those public officials responsible for the approval of manifestly unlawful, inequitable, or irregular transaction or acts by the board, panel, or group to which they belong. Kanina, si public officer intervenes individually in a proceeding where there is conflict of interest or that he is prohibited by law to do so. Now, in this paragraph, approval of board, panel, or group of which he is a member and which exercises discretion in such approval naman ang involved. Moving on to paragraph J. Moving on to paragraph J. Yan. Knowingly approving or granting any license, permit, privilege, or benefit in favor of any person not qualified for or not legally entitled to such license, permit, privilege, or advantage, or of a mere representative or dummy of one who is not so qualified or entitled. Himayin natin. Excuse me. Knowingly approving or granting any license, permit, privilege, or benefit in favor of, nag-approve, nag-grant ng license, permit, privilege, or benefit, si public officer knowingly, nag-approve siya to any person not qualified, for or not legally entitled to such license, permit, privilege, or benefit. Or knowingly approving or granting the same to a mere representative or dummy of one who is not so qualified or entitled. Examples here are when certifications, licenses, or permits were issued, where in truth and in fact, the requirements for the issuance of the same were non-existent or otherwise incomplete, or that the person receiving it is disqualified or not entitled. In short, si public officer nang accommodate at nagbigay, nag-issue ng license, permit, or privilege without basing his decision on the requirements provided for by law prior issuing said license, permit, privilege, or benefit. Okay. We have here an example, the case of People versus Sandigan Bayan, March 28, 2006. The municipal mayor and the entire Sangguniang Bayan were all charged of violating this provision. Okay. Saang bayan ito? Sabi ko po were charged. Hindi sila convicted. Fortunately or unfortunately, 2006 case. The municipal mayor and the entire Sangguniang Bayan of Calamba, Laguna were all charged for violating this provision for granting Australian Professional Realty Incorporated the privilege of constructing the shopping center located at Calamba, Laguna, despite knowledge that the said construction firm, si APRI, Australian Professional Realty Incorporated, despite knowledge that the said construction firm is not qualified, not being accredited by the PICAB or the Philippine Contractors Accreditation Board as Class AAA, as Class AAA contractor, because it has only a paid-up capital of 125,000 pesos. Wow. Imagine that. 125,000 pesos Philippine currency. At, ladies and gentlemen, ang amount ng project, 200 to 300 million pesos lang naman. Imagine that. 125,000 pesos ang paid-up capital ng isang kontraktor na magtatayo ng 200 to 300 million worth. Kaya nga itong kontraktor na to, hindi siya accredited ng PICAB, ng Philippine Contractors Accreditation Board as Class AAA contractor. However, the court that decided is Supreme. The Supreme Court. The Supreme Court decided, fortunate or unfortunately, hindi ko alam kung saan tayo dyan, all accused, mayor, all members of the Sangguniang Bayan, hoping na hindi sila kasama ngayon sa webinar natin. Kasi Region 1, sana po, Region 1 lang. Luckily, all got away because the court, the highest court, the Supreme Court, reasoned that APRI, Australian Professional Realty Incorporated, is, according to the decision, under a BOT, Build, Operate, Transfer project proponent, and not a contractor, sabi. BOT project proponent lang daw si APRI, Australian Professional Realty Incorporated. And therefore, it is not required to be registered and accredited by the PICAB. Sabi ni Supreme Court, APRI is a BOT project proponent and not a contractor to undertake actual construction for the project, and thus APRI need not register with and be accredited by the PICAB. Ayon nga po sa laging sinasabi ni Mike Enriquez, nakalusot. Moving on. Paragraph K. Paragraph K, ladies and gentlemen, on to our final prohibited act. On to our final prohibited act, divulging valuable information of a confidential character acquired by his office or by him on account of his official position to unauthorized persons, or second part, or releasing such information in advance of its authorized release date. Hindi pa pinapublish kung ano yung kailangan, halimbawa ni head of procuring entity, mayroon ng bid. No, just kidding. Yun yung one good example dito. Okay, himayin natin. Divulging valuable information of a confidential nature or confidential character, of which the public officer acquired the same due to his official function or of his office rather, then it was divulged to an unauthorized person, or releasing such information in advance of its authorized release date. Yan. Okay. Those, ladies and gentlemen, were the specific enumerations under Section 3 of RA 3019, kung ano-ano yung mga prohibited acts considered as graft and corrupt practices under RA 3019. Now, to reiterate, even private individuals who commit acts violative of the provisions of RA 3019 can be held criminally liable hereto. In one celebrated case, even if the public officer who was in conspiracy with the private individual already died, the latter, meaning the private person rather, can still be held criminally liable thereof. Ang ibig nating emphasize, hindi ibig sabihin that we are talking about graft and corruption ay public officers lang ang pwedeng makasuhan. We are emphasizing that even private person committing any of the unlawful acts hereto are possibly can be prosecuted under this law. Sabi pa nga sa isang case, kahit patay na yung public officer, naka-conspire ni private individual, magtutuloy yung kaso against the private individual. That is a case of People of the Philippines versus Henry T. Go, March 25, 2014. Okay. Excuse me. Case in point, People of the Philippines versus Henry T. Go, March 25, 2014. Ano bang nangyari dito? An information was filed against respondent. The information filed against respondent is an offshoot of the Supreme Court's nullification of various contracts awarded by the government. Subsequent to the decision, a certain Pesayco filed a complaint with the Office of the Ombudsman against several individuals for alleged violation of RA 3019. Si Pesayco may mga kinasuhan. Among those charged, may mga finailan ng kaso rather. Among those charged was respondent Henry T. Go, who was then the chairman and president of PIATCO for having supposedly conspired with then DOTC pa noon, Secretary Arturo Enrile, may his soul rest in peace, Secretary Enrile, in entering into a contract which is grossly and manifestly disadvantageous to the government. The Office of the Deputy Ombudsman for Luzon found probable cause to indict, among others, Henry T. Go for violation of Section 3G of RA 3019. Tapos na natin yan kanina. While there was likewise a finding of probable cause against Secretary Enrile, kahit na mayroong finding of probable cause against then Secretary Enrile, he was no longer indicted. Bakit? He died prior to the issuance of the resolution finding probable cause. Ito ang naging desisyon ni Sandigan Bayan. The Sandigan Bayan issued an order to show cause why the case should not be dismissed for lack of jurisdiction over the person of the accused. Considering that the accused is a private person and that the public official Arturo Enrile, then Secretary of DOTC, his alleged co-conspirator, was already deceased and not an accused in the case. The Sandigan Bayan granted the motion to quash and the information filed in this case was ordered dismissed. Hence, it reached the Supreme Court. The issue now is whether the death of a public officer in a crime extinguishes the liability of his co-conspirators, such as herein respondent Henry T. Go. Ang sabi ni Supreme Court, no. It is true that by reason of his death, there is no longer any public officer with whom respondent can be charged for violation of RA 3019. It does not, however, mean that the allegation of conspiracy between them can no longer be proved or that their alleged conspiracy is already expunged. Sabi ni Supreme Court, the requirement before a private person may be indicted for violation of Section 3G of RA 3019, among others, is that such private person must be alleged to have acted in conspiracy with a public officer. The law, however, does not require that such person must, in all instances, be indicted together. The law, however, does not require such person must, in all instances, be indicted together with the public officer. Sabi pa ni Supreme Court, if circumstances exist where the public officer may no longer be charged in court, as in the present case, kasi patay na nga, the private person may be indicted alone. Yan ang sabi sa case ni People of the Philippines versus Henry T. Go. Okay, here is a simple exercise for everyone. Question: may a public officer charged under Section 3B of Republic Act RA 3019 directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself, for any other person in connection with any contract or transaction between the government and any other party wherein the public office in his official capacity has to intervene under the law, also be simultaneously or successively charged with direct bribery under Article 210 of the Revised Penal Code. Pwede bang magsabay na kasuhan ang isang tao, private man or public officer, private individual man or public officer, ng violation ng Anti-Graft and Corrupt Practices Act and violation of Article 10 of the Revised Penal Code, which is bribery? The answer is yes, of course, yes. Public officer charged under RA 3019 may also be simultaneously or successively charged for the crime of direct bribery under Article 210 of the RPC, because two crimes are essentially different and are penalized under distinct legal philosophies. Anong ibig sabihin natin? Violation of RA 3019 is malum prohibitum. The crime under 210 of the code is malum in se. One is prohibited per se, one is specifically considered prohibited by virtue of a legislative declaration. Ayan. Those, ladies and gentlemen, are the salient provisions of Republic Act 3019 or the Anti-Graft and Corrupt Practices Act, which specifically defines the criminal acts of graft and corruption that may be committed by any public employee or official or private individual. We now move on to another special penal law, the Anti-Plunder Act, RA 7080 as amended. Yan. Plunder. That is the definition of plunder in your screen. It is a crime committed by a public officer by himself or, laging or, in connivance with members of his family, relatives by affinity or consanguinity, business associates, never be an associate talaga, subordinates or other persons by amassing, accumulating, or acquiring ill-gotten wealth. Naka-emphasize po dyan ang ill-gotten wealth through a combination or series of overt acts in the aggregate amount or total value of at least 50 million pesos. And that is the exact definition, complete and exact definition of plunder. Under the said definition, there must be at least 2 predicate crimes committed before one can be convicted of plunder. Bakit? Sabi dyan, kasi ang requirement, combination or series of overt acts. Combination or series of overt acts. Therefore, there must be at least 2 predicate crimes committed before one can be convicted of plunder. Okay. Himayin natin, dalawang elements. That the offender is a public officer who acts by himself or in connivance with members of his family, relatives by affinity or consanguinity, business associates, subordinates, or other persons. Then next, that he amassed, accumulated, or acquired ill-gotten wealth, the aggregate amount of which is at least 50 million pesos through a combination or series of criminal overt act. Yan. Before we enumerate the same, yung combination of or series of overt act na pwedeng mag-amass or accumulate ng ill-gotten wealth leading to plunder, let's define ano nga ba yung ill-gotten wealth. Ill-gotten wealth is any asset, property, business enterprise, or material possession of any person acquired by a public officer directly or indirectly through dummies, nominees, agents, subordinates, and or business associates. Associates na naman. Why am I saying? Kasi dagdagan natin ng humor. Mahirap daw maging associate kasi aso ka na. Shit ka pa. Anyway, it is acquired by any combination or series of the following means or similar schemes, meaning at least dalawang predicate crimes which we will enumerate ang nagawa prior magkaroon ng conviction ng plunder. Yan. A and B. Misappropriation, conversion, misuse, or malversation of public funds or raids on the public treasury. Receiving directly or indirectly any commission, gift, share, percentage, kickback. Yan. Pasadahan na lang natin due to time constraints. Yan. Next, 6 po yan, 6 na acts. Legal or fraudulent conveyance or disposition of assets belonging to the government. Obtaining, receiving, or accepting directly or indirectly shares of stock, equity, etc. Yan. Then lastly, ENF, establishing agricultural, industrial, commercial monopolies. Or lastly, paragraph F, taking undue advantage of official position, authority, relationship, connection, or influence to unjustly enrich himself or themselves at the expense and to the damage and prejudice of the Filipino people and the Republic. Okay. Yan yung mga means. Okay. Let's have a short background of RA 7018. The law was enacted as an aftermath of the Marcos dictatorship when then President Ferdinand Marcos, his wife Imelda, and their cronies allegedly amassed ill-gotten wealth. After the 1986 People Power Revolution, the government found that existing laws like the Anti-Graft and corrupt practices were clearly inadequate to cope with the magnitude of the corruption and thievery committed during the past administration. Okay? According pa sa statement ni former Senator Jovito Salonga, sabi niya, the existing law, RA 3019, clearly is inadequate to cope with the magnitude of the corruption and thievery committed during the Marcos years. Those are the words of former Senator Jovito Salonga. In response to this, anti-plunder bills were filed by Salonga in the Senate and by then Representative Lorna Yap in the lower house during the 9th Congress. Then luckily, the bills were consolidated into Republic Act 7080 signed by President Aquino in 1991. Yan, tignan natin yung mga plunder cases sa Pilipinas. The first plunder case was filed August 15, 1997, when then Commissioner Liwayway Vincent Chato of the BIR sued their cashier, Dominga Manalili, and 6 others for 2 counts of plunder. Take note, ladies and gentlemen, ang parusa ng plunder ay reclusion perpetua to death. Yan. Luckily, RA 9346 na held in abeyance ang execution, death execution. Now, Manalili and her accomplices were accused of diverting a total of 260 million or around $9.9 million, 260 million pesos of withholding tax payments of government and private employees to unauthorized bank accounts in 1996. Makalipat yun sa BIR. Just kidding. Nearly 4 years later, in May 2001, Manalili became the first person to be convicted of plunder in the Philippines. She was sentenced by Quezon City Regional Trial Court Judge, now Supreme Court Associate Justice Diosdado Peralta. Nag-retire na ba? Nag-retire na. To 2 life terms and was ordered to return the money she stole, plus all profits earned. Her accomplices were also found guilty of plunder. Meanwhile, charges against 2 other defendants were dismissed due to insufficient evidence. Yan. The first ever plunder case. Yan. Sino ba naman ang hindi makakaalam itong next plunder case natin? Manalili's conviction happened in the midst of a historic plunder case involving former President Erap Estrada. On April 4, 2001, former President Erap Estrada, his son Jinggoy Estrada, and 6 others were charged with plunder. The Estradas were the first elected officials to be charged. Jinggoy Estrada was the first incumbent elected official to be sued. He was the mayor of San Juan at the time the plunder case was filed. President Estrada was accused of amassing a combined 4 billion pesos, mainly from wedding payola payoffs and misappropriation of the tobacco excise tax funds. 6 years later, on September 12, 2007, Estrada, former President Estrada was found guilty of plunder and sentenced to life imprisonment. His son Jinggoy and lawyer Edward Serapio, however, were acquitted. Ito ang twist. On October 26, 2007, however, former President Erap Estrada was able to secure a pardon from then President Gloria Macapagal Arroyo. Yan. Then, our next plunder case, the plunder case. July 16, 2012, President Arroyo became the second former president to be charged with plunder. The Office of the Ombudsman filed a 366 million worth of plunder case against Arroyo, 7 Philippine charity sweepstakes, 7 Philippine charity sweepstakes office PCSO officials, and 2 COA officials over alleged misuse of PCSO intelligence funds. Nota, kasama sa nakasuhan 2 COA officials for alleged misuse of PCSO intelligence funds. In October 2013, another plunder complaint was filed against Arroyo, this time over the misuse of the discretionary Malampaya Fund. Included in the charge sheet, medyo nahuli po, included in the charge sheet, are alleged pork barrel scam mastermind Janet Lim Napoles, political liaison Ruby Tuwason, and many others. Okay? Of course, the rest now is considered history. Naging member pa nga ng House of Representatives si former President Gloria Macapagal Arroyo. I will not discuss any further in her plunder case because the rest has already been part of history. Nan, puntahan naman natin ngayon ang revised penal code. Yan, halos sakto-sakto lang tayo sa oras. Puntahan naman natin ang ating revised penal code, malversation of public funds or property. Yan, lagi natin itong naririnig. Malversation of public funds or property. Pahapyaw lang po yung topic kasi isa lang ito sa mga ni-request sa atin na idagdag na lang. Malversation of public funds or property. This includes malversation by appropriating, misappropriating, or permitting any other person, malversation by appropriating, misappropriating, or permitting any other person to take public funds or property. That's Article 217. Then Article 218, failure of an accountable public officer to render public accounts. Number 3, failure of a responsible public officer to render accounts before leaving the country. Number 4, illegal use of public funds or property. Article 220 and Article 221, failure to make delivery of public funds or property. Pasadahan lang po natin, general provisions lang tayo. Then little bit of examples. What are the common elements to all acts of malversation? Of course, the offender is a public officer. He had the custody or control of funds or property by reason of the duties of his office. Therefore, he is an accountable officer. Number 3, those funds or property were public funds or property for which he was accountable. He is an accountable officer. And number 4, he appropriated, took, misappropriated, or consented, or through abandonment, negligence, permitted another person to take such public fund. Okay. Note that malversation is predicated on the relationship of the offender to the property or funds involved. His or her being remiss in the duty of safekeeping, dapat under custody niya yung public fund, dapat safe and in safe hands dapat. His being remiss or her being remiss in the duty of safekeeping public funds violates the trust reposed by reason of the duties of his or her public office. Nabanggit natin kanina sino mga accountable officers. Tignan natin, sino nga ba? Who is an accountable? Yan. Okay. Now, it must also be noted that it is not necessary, before we proceed sa accountable public officer, it must also be noted that it is not necessary that the offender actually misappropriated the funds. It is enough that he has violated the trust reposed on him in connection with the property. Kaya nga, mayroong malversation by abandonment or negligence. Next, proceed tayo. Who is an accountable public officer? Yan. An accountable public officer within the purview of Article 217 of the Revised Penal Code is one who has custody or control of public funds or property by reason of the duties of his office. The nature of the duties of the public officer or employee, the fact that as part of his duties, he received the public money for which he is bound to account and failed to account for it. It is the factor which determines whether or not malversation is committed by the accused public officer or employee. pinagkatiwalang public funds sa kanya, wherein he or she is required to account the same. And when accounted, he or she cannot do so. Therefore, he can be held liable for malversation of public funds. This is so provided in the case of Torre versus People of the Philippines, August 31, 2011 case. Moving on to what is noted as a prima facie evidence of malversation. It is so noted that the failure of a public officer to have duly forthcoming any public fund or property with which he is chargeable upon demand by any duly authorized officer shall be prima facie evidence that he has put such missing funds or property to personal uses. Candao versus People, 2011 case. Anong ibig sabihin? Ano ba ang ibig sabihin dito? You are an accountable officer, for example. Accountable ka sa pera, meaning you have to justify its disbursement, or kung tinanong at dapat mong i-account, you cannot do so. The presumption is there is a prima facie evidence of malversation. The prima facie evidence is he, that public officer, has put such missing funds or property to personal use. Note, however, sabi rin sa kasong ito, note, however, demand is not indispensable to constitute malversation. It merely raises a prima facie presumption that missing funds have been put to personal use. Halimbawa, nag-i-investigate si COA. Pinapa-account sa'yo, hindi mo na-account. There is a prima facie presumption that missing funds have been put to personal use. Candao versus People, October 19, 2011 case. The crime of malversation can be committed by negligence. Ayan. Sabi na natin yan kanina. Let's give an example. Yan. Here's a case. We're almost done. Messina, a local treasurer officer 1 of Caloocan City, collected the city's collection for June 1998 from Baklik at the mini city hall. Messina acknowledged the receipt of the said funds. On the same day, Baklit received several phone calls, including a phone call from Coleto saying that the patubig collection was not remitted. The other phone call was from Messina saying that he did not receive the patubig collection. The following morning, Mayor Malonzo asked Messina about the said funds, and Messina denied receiving it. During the investigation, Messina's vault was opened for cash count. Thereafter, Messina admitted that he collected the patubig collection but kept the money in his vault. Is Messina liable for malversation? Yes. Ang sinasabi niya kasi, ang defense, alibi, or palusot. Ang defense or alibi ni Messina dito, hindi niya intensyon. Nanakaw, nawala. Take note, ladies and gentlemen, in the case of Messina versus People, June 17, 2015, malversation is committed either intentionally or by negligence. All that is necessary for conviction is sufficient proof that the accused accountable officer had received the funds or property and did not have him in his possession when demand therefore was made, without any satisfactory explanation of his or her failure to have them upon demand. In the case at bar, Messina feigned ignorance. Supreme Court na mismo nagsabi na nagpapalusot lang si Messina. Messina feigned ignorance of having received the patubig collection when he phoned Baklit to tell her that he did not receive the collection. Okay? So i-emphasize natin, crime of malversation can be committed by negligence. Moving on, the required proof in order to convict an accused of malversation. All that is required to prove is that the defendant received in his possession public funds, that he could not account for them and did not have them in his possession, and that he could not give a reasonable excuse for disappearance of the same. Since 1982, yan ang required proof in order to convict an accused of malversation. Okay, yan pa rin ang required proof at this point in time. Okay, the return of the money in the same case. Sabi, the return of the money malversed is merely a mitigating circumstance. It cannot exempt the accused from criminal liability thereof. Kahit pa binalik mo thereafter, criminally liable ka pa rin. Let's proceed. We now move on to technical malversation. Okay. You can see in your screen elements of technical malversation. However, nakalagay din dyan sa heading illegal use of public funds or property under Article 220 of the Revised Penal Code. In technical malversation, the public officer applies public funds under his administration not for his or another's personal use, but to a public use other than that for which the fund was specifically appropriated by law or ordinance. Hindi naman niya ginamit sa kabalbalan o personal na kaginawaan or kagustuhan, pero ginamit ang public fund na specifically appropriated. Ginamit yung fund na yun sa ibang public use. Hence, technical malversation. Illegal use of public funds or property is also known as technical malversation. Technical malversation is therefore not included in, nor does it necessarily include the crime of malversation of public funds charged. Thus, in the acts constituting the crime of technical malversation, which are not alleged, thus, in one case rather, it has been said by the Supreme Court that the acts constituting the crime of technical malversation were not alleged in the information. The person accused cannot be convicted of malversation. Ang ibig lang sabihin dito, ang ibig nating emphasize, kung yung fund ay hindi specifically appropriated for a certain public use at ginamit ito for other public use, walang nagaganap na technical malversation. To emphasize rather, instead of applying it to the public purpose for which the fund or property was already appropriated by law, the public officer applied it to another public purpose. Doon pumapasok ang technical malversation. Almost done. Here is a case. Sabi, as our guide in answering the question on your screen, sabi in the case of Abdullah versus People of the Philippines, in the absence of a law or ordinance appropriating public fund allegedly technically malversed, the use therefore for another public purpose will not make the accused guilty for technical malversation. Here is a case. Paano kung ganito? Ex-appropriated the salary differentials of secondary school teachers of Sulu State College, contrary to the authorization issued by the DBM. Can X be held liable for technical malversation? Ang paggamit ng fund ay specifically public fund, is specifically authorized by the DBM. Authorization from DBM ang pinag-usapan. Sabi natin kanina, if ang fund ay specifically appropriated by law or an ordinance, hindi mo pwedeng gamitin for another public use. Bakit? Technical malversation yan. Paano itong kaso? Itong example natin. May DBM authorization kung saan ang specific public fund ay doon lamang gagamitin. Pwede bang ma-held criminally liable for technical malversation si X? Sabi sa Abdullah versus People 2005 case, no. The third element is lacking. The authorization given by DBM is not an ordinance or law contemplated in Article 220. Yan. Ladies and gentlemen, I would like to discuss more, but due to time constraints, I have to conclude my discussion. Okay, there you have it, ladies and gentlemen. Indeed, makikita natin that our country is replete of laws, excellent laws at that, is specifically enacted to curb the seemingly perennial problem on graft and corruption. Unfortunately, however, the same remains futile. Most probably, it is due to the unwarranted mentality that a transgression of law remains an unpunished violation if the same remains unknown. Sinong nagsabi nun? Ako lang po. Ito ang ating paniniwala. Most probably, kahit gaano karaming batas providing or curtailing and curbing graft and corruption, ang ating personal na paniniwala, graft and corruption remains because a transgression of law remains an unpunished violation if the same remains unknown. Hence, at this juncture, ladies and gentlemen, allow me to encourage all of you to be a catalyst of change to that kind of mentality. As public servants, let us uphold the time-honored principle that public office is a public trust. Diyan tayo nag-start kanina. As a final statement naman, let me leave you with this point to ponder. Be honest, even if others are not, even if others will not, even if others cannot. He who walks honestly walks securely. Again, ladies and gentlemen, naimbag nga aldawen apo. Naimbag nga aldaw kada tayo amin, mabuhay tayong lahat. God bless everyone.
Nagyaman kami, Attorney Philip Raymond Rivera, sa napakamalaman at ang dami-dami pala. So maraming salamat, sir, sa mga ibinahagi niyo po sa amin ngayong umaga. And with that, kung may mga katanungan po tayo or comments, just raise your hand or type your questions sa chat box natin. Yes, mga message po dito, attorney. Salamat po, Attorney Rivera. Very informative po ang inyong diniscuss ngayong umaga. Okay, so ang dami nating natutunan sa RA 3019, RA 7080 at ang ating revised penal code. Attorney nga pala, marami pong nagre-request ng copy kasi ng presentation.
Yes. I-send ko po.
Thank you.
Ibigay ko na lang kay Attorney Patrick.
Yes, sir. Thank you very much po. Ayun po, i-share po sa atin ni Attorney ang copy po ng kanyang presentation and we will share this to everyone po para at least aware.
Basta ma'am, pag ginamit nyo po as your presentation, huwag nyo akong kalimutan ha sa mga makakakuha ng copy.
At saan nga ba matatagpuan na section yun, sir?
IPR po, Intellectual Property. Banggitin nyo lang po ako, sabihin nyo lang kung ginamit nyo sa lecture ninyo, ayon sa nasabi ng isang public employee.
Yes, sir. Ayon. Salamat, sir. Ayon po sa ating napakagaling na attorney po. Maraming salamat po ulit. May mga katanungan po ba? Mukhang klarong-klaro po. Ano po?
Lahat nagpapasalamat. Welcome po.
Thank you. Thank you po. Nga po pala, remind namin yung mga hindi pa po fill out ng attendance form natin sa link natin and sa pre-assessment natin. Okay, habang hinihintay natin ang mga katanungan, kung meron man po, i-recap lang natin ano yung nangyari po ngayong umaga. Ano po? So kanina, of course, we had our undersecretary, si Yusek Densing po, na namahagi ng kanyang opening remarks. And then, na-discuss po sa atin ni Mr. Mapile Jr. ang Bantay Korapsyon Program, kung ano po ang Bantay Korapsyon, ano yung sa citizen participation in anti-corruption. And of course, si Attorney Rivera po sa pag-discuss niya ng RA 3019, RA 7080, at ang ating revised penal code. So, I think wala yata tayong mga katanungan at 13 minutes, mag-aalas 12 na, attorney. Babahagi na lang po natin ang ating presentation. May comment lang dito pala from LGU Mabini. It is so sad that some big cases mentioned, Replander, still remain a big question mark. Ayan. So, Sir Leo, pakisend lang po ulit yung link natin for the attendance. So, ayun po. Bago po tayo mag-close, kung wala na po tayong mga katanungan, we would like to call also our Regional Director, Ma'am Julie Dakiwag, to please give us the closing remarks po.
Yeah, thank you, Alet. Thank you so much, Attorney Rivera, Bigat. We learned so much from you, Yusek Densing, ang ating Mr. George Mapili, si Attorney Patrick and Sosimo, and sa lahat ng ating regional, provincial, city municipal officers, ang ating local chief executives who are here with us, joining us, LGU functionaries, and I think this is one of the best, very informative at that na ginawa natin sa webinar pertaining to Bantay Corruption on reinforcing, of course, public accountability for government units and civil society organizations. So, Rivera, that we should be a catalyst for change. But before we can affect change to other people, let's look at the individual. Let's look at ourselves. Tayo ba alam ng itong mga ito? At we need really to be aware so that we can deter and we can prevent these things, cases being filed to us and to local government unit officials, public officials, and the rest, and private persons also. So informative that we need really to have hindi lang siguro monthly or we'll do it quarterly, attorney. We will invite you again. Please do not please, wag kang mawalan ng time sa aming DILG because really itong mga senior ninyo ay that's very those things are very important for us, most especially if you are holding public office and sinasabi natin really that the public office is a public trust. Okay, so over and over sinasabi natin yan, but there are still officers committing such, and yung push natin for change, ito kailangan natin. So kailangan yung individual reflection pertaining to how we implement things, we implement our programs and projects, how we do administrative, technical, and so on and so forth in the local government units man or in the public offices. So we are very thankful, Yusek Densing, ang ating Mr. Mapili, Attorney Rivera, ang ating Bantay Korapsyon, Patrick and the rest. Because if no mga corrupt activities na to, walang mangyayari sa atin sa Pilipinas. But we need really to know broader scope and aspects of Bantay Korapsyon, more webinars, more lectures, and this. So we're hoping that Attorney Rivera will be free again if we will be asking for his time, lalo na we are kapitbahay naman. So I hope we can do a stronger partnership, attorney, so that we can also assist and help our local government officials and local government units pertaining to how we implement Bantay Korapsyon. Bantayan natin lahat, tulong-tulong tayo, and we can only do this if we are well versed with with all the different flaws na kita niyo, most especially so more coming in. So pang pa-buenas ng second sem ito, Attorney Rivera. Thank you so much. And from the Department of Interior and Local Government Region 1, I'm so proud and privileged to have met you all this morning sa ating webinar. Sana magtulungan tayo, bantayan natin yung dapat nating bantayan. So good morning everyone. Alam ko that we cannot give what we do not have. So more webinars on this Bantay Korapsyon and other laws pertaining to how we implement Bantay Korapsyon. Thank you so much, everyone. Good morning. Stay safe, lahat-lahat.
Thank you. Thank you very much, Ma'am Julie. And ma'am, before you leave, and Attorney Rivera and Sir Mapili, pwede po ba tayong mag-photo ops? Para may documentation lang po. Pa-assist na lang po sa ating mga kasama sa Eric 2. Ayan. So, paki-turn on po ang ating mga cameras. Okay, may 8 pages tayo. Start natin sa page 1. Smile. 1, 2, 3. Next. Smile. Ayan, nagaganda ng ngiti. 1, 2, 3. Next. Smile. 1, 2, 3. Smile lang po ng smile. Last 2 pages. Ayan. So again, maraming salamat po sa inyong pag-join ngayong umaga. Stay safe po sa inyong lahat and God bless you all.
Thank you po. Thank you.
Sir Leo, pwede ba, may ano na po, may i-share na natin, sir? Yung ano, tawag nito, presentation. Kung wala pa po dyan yung link, isasend na lang po namin sa mga email addresses po ng provincial offices para ma-share na po sa lahat ng ating mga participants. Sa mga nag-type po dito sa chat box ng kanilang email addresses, i-check na lang po namin, send na lang po namin sa inyo. Thank you po. So, mo yung camera mo, nakikita yan. Sana all my lunch.